Flammorschale Fokusstrategie Dienstag, 18. Januar 2022. Tadic case, the verdict. Counts 18 to 20. In brackets, paragraph 9. The events alleged are said to have occurred at the Omarska camp in late June or early July. The defense contention that the accused was never at the Omarska camp and that in any event at the relevant time his duties with the traffic police precluded him from having committed the acts alleged is rejected by the trial chamber. Numerous credible witnesses have testified that they saw the accused at the camp and the accused's assignment to the Orlovci checkpoint would not preclude him from carrying out what the prosecution described as his higher duty as a traffic policeman to implement ethnic cleansing to achieve a greater Serbia. Accordingly, the trial chamber rejects the accused's alibi and his assertion that he was never at the Omarska camp. Counts 21 to counts 23. In brackets, paragraph 10. The events charged in this paragraph appear to have occurred on 7 or 8 July 1992. The trial chamber finds that the assignment records for the Orlovci checkpoint do not provide the accused with an alibi. The assignment records reflect that on those nights the accused was off duty. On 7 July 1992, the accused was off duty after 7 a.m. and offered no testimony regarding his whereabouts. On 8 July 1992, the records reflect that he completed his assignment at 7 p.m. and he likewise offered no testimony regarding his whereabouts at the time these events occurred. Prijedor is about 20 kilometers from the Omarska camp. The travel time is 30 to 35 minutes by car. Counts 24 to 28, in brackets, paragraph 11. This paragraph charges the accused with events occurring around 27 May 1992 in Kozarac. 3 witnesses were called by the prosecution to give evidence about the accused's role, and additional prosecution witness testimony sought to establish the accused's presence in Kozarac on this day. While noting inconsistencies between the evidence of these witnesses, the trial chamber found that the evidence of all or any or 4 defense witnesses who had passed through Marsalatita Street does not afford an alibi to the accused except to indicate that they did not happen to see the accused in Kozarac on that day while they were there. Counts 29 to 34, in brackets, paragraph 12. The events are alleged to have happened around 14 June 1992 in ICTY and ICTY. The trial chamber found that the accused's alibi does not deal specifically with 14 June 1992 and is generally unspecific as to date in respect of this period. 4. The inapplicability of the counts charging the accused with grave breaches. Three was the accused's defense of alibi. 2 was factual and legal findings count by count. And there is no number 1. Or it is the verdict reads as follows. Perhaps the verdict, but there's no number, just the verdict reads as follows. The inapplicability of the counts charging the accused with grave breaches. The trial chamber, by a majority of 2 to 1 in brackets, Judge MacDonald dissenting, close brackets, finds that the accused could not be charged with grave breaches under Article 2 because the alleged victims were not protected persons under Article 4 of the 4th Geneva Convention of 1949. For that reason, Article 2 is inapplicable in brackets except in respect of citizens of the Republic of Bosnia and Herzegovina who actually found themselves in the hands of the GNA, Yugoslavia's People's Army. Before 19 May 1992 of the VG, Army of the Federal Republic of Yugoslavia. And FRY, Federal Republic of Yugoslavia. After 19 May, in consequence of these findings, count 5, 8, 9, 12, 15, 18, 21, 24, 27, 29, and 32 have been dismissed. In order to Article 2 to be applicable, the victims must be protected persons, and the conflict must be international in character. The majority finds that while, from the beginning of 1992 until 19 May 1992, a state of international armed conflict existed in at least part of the territory of Bosnia and Herzegovina, between the forces of the Republic of Bosnia and Herzegovina on the one hand and those of the Federal Republic of Yugoslavia, in brackets, Serbia and Montenegro, being the GNA, later the VG. So GNA, it went from GNA to VG, so there was a transformation of the army, and perhaps not only by its name. Working with sundry paramilitary and Bosnian Serb forces on the other. After 19 May 1992, this armed conflict was not of a character to justify the imposition of Article 2, in brackets, grave breaches, close brackets, of the statute, because the victims were not protected persons, that is, they were not in the hands of a party to the conflict or occupying power of which they were not nationals. On 19 May 1992, the GNA officially withdrew from the Republic of Bosnia and Herzegovina. The question for this trial chamber is whether, after 19 May 1992, the Federal Republic of Yugoslavia by its withdrawal from the territory of the Republic of Bosnia and Herzegovina, and notwithstanding its continuing support for the VRS, Army of Republika Srpska, had sufficiently distanced itself from the VRS so that those forces could not be regarded as de facto organs or agents of the VG and hence of the FRY. If the agency relationship could be proven, then acts committed by the VRS against nationals of the Republic of Bosnia and Herzegovina could be considered to be acts against non-nationals. In deciding what constitutes agency for the purposes of the applicability of Article 2, the Chamber considered the case concerning military and paramilitary activities in and against Nicaragua, which was decided by the International Court of Justice. While noting that that case was concerned with the responsibility of a state and the extant case is concerned with the responsibility of individuals, and that the facts of each case are substantially different, the majority applied the essence of the test, which they considered to be laid down in Nicaragua. There, the International Court of Justice asked whether or not the relationship of the Contras to the US government was so much one of dependence on the one side and control on the other that it would be right to equate the Contras for legal purposes with an organ of the US government or as acting on behalf of that government. In the context of the extant case, the test would be whether the requisite degree of command and control by the VG and hence by the FRY over the VRS is established for the purpose of imputing the acts of those forces operating in Obstina, Prijedor, or the VRS as a whole to the FRY. According to the Chamber, the prosecutor must provide that the nature of the relationship between the VRS and the government of the FRY and between the VRS and VG in particular was of such a character. In doing so, it is neither necessary or sufficient merely to show that the VRS was dependent, even completely dependent, on the VG and the FRY. For the necessities of war, it also must be shown that the VG and the FRY exercised the potential for control inherent in that relationship of dependency, or that the VRS has otherwise placed itself under the control of the government of the FRY. In other words, the test is one of effective control. The trial chamber found that there were two relationships of special importance to the determination. One, that between the General Mladic and the VRS main staff in Belgrade, and two, that between the SDS in brackets and hence RS close brackets and the government of FRY. While finding that there was so coordination between the VRS main staff and the VG main staff in Belgrade, the majority held that coordination is not the same as command and control. The only other evidence submitted by the prosecution was that, in addition to routing all high-level VRS communications through secure links in Belgrade, a communications link for everyday use was established and maintained between VRS main staff headquarters and the VG main staff in Belgrade. No further evidence was led by the prosecution on the nature of this relationship. So this means that there is a relationship between VG and VRS. So direct communication between headquarter of VG and VRS. Regarding the majority noted that the political leaders of RS were popularly elected by the Bosnian Serbs of the Republic of Bosnia and Herzegovina, and the independence of RS was declared by a vote. RS, that's the Republika Srpska. And the independence of RS was declared by a vote of the Bosnian Serb Assembly, and asked whether, in spite of this, it could infer that the necessary degree of effective control was exercised by the FRY over the military operations of the RS armed forces, and find that the VRS was nothing more than a de facto organ or agent of the FRY. The majority found that there was no evidence that non-Bosnian Serb members of the VRS were specifically charged by Belgrade with the carrying out of certain acts of its behalf. Secondly, while it is clear from the evidence presented that the pay of all 1st Krajina Corps of officers and presumably of all senior VRS commanders as former GNA officers continued to be received from Belgrade after 19 May 1992, such evidence without more established nothing more than the potential for control inherent in the relationship of dependency which such financing produced. The trial chamber noted that the military and political objectives of the RS and of the FRY were largely complementary and dedicated to the creation of a greater Serbia. Therefore, there was little need for the VG and the government of the FRY to attempt to exercise any real degree of control over, as distinct from coordination with the VRS. Thus, while it can be said that the FRY, through the dependence of the VRS on the supply of material by the VG, had the capability to exercise great influence and perhaps even control over the VRS, there is no evidence on which this trial chamber can conclude that the FRY and the VG ever directed or, for that matter, ever felt the need to attempt to direct the actual military operations of the VRS, or to influence those operations beyond that which would have flowed naturally from the coordination of military objectives and activities by the VRS and VG at the highest levels. In sum, while the evidence available to this trial chamber clearly shows that the various forms of assistance provided to the armed forces of the RS by the government of the FRY was crucial to the pursuit of their activities, and that those forces were almost completely dependent on the supplies of the VG to carry out offensive operations, evidence that the FRY, through the VG, made use of the potential for control inherent in that dependence, or was otherwise given effective control over those forces, and which it exercised is similarly insufficient. It is of course possible, on or in spite of the evidence presented, to view the acts of the GNA and the government of the FRY on or about 19 May 1992 as nothing more than a cynical and intentional creation of the objective factors necessary to distance themselves from direct legal responsibility for the acts of the armed forces of the RS, while doing everything to ensure that the material factors necessary to ensure the successful continuation of the armed conflict to achieve the same military and political goals were kept in place, even if the legal effect of creating such objective factors, which caused no small amounts of difficulty to the GNA and the government of the FRY, could be vitiated by reason of some fraudulent intention, which this trial chamber doubted. That is not the only nor the most reasonable conclusion open on the evidence presented. There is, in short, no evidence on which this trial chamber may confidently conclude that the armed forces of the RS and the RS as a whole were anything more than allies, albeit highly dependent allies, of the government of the FRY. Thus, the trial chamber is, by majority, with the presiding judge dissenting, of the view that, on the evidence presented to it after 19 May 1992, the armed forces of the RS could not be considered as de facto organs or agents if the FRY, either in obstrina priedor or more generally. In the next video, I will continue with separate this and dissenting opinion of Judge MacDonald.